Welcome to Law You Should Know. The law affects every aspect of our lives, our home, our jobs, and our recreational activities. Now you can learn about the law and how to protect yourself against the loss of your liberty or property. Learn how to stand up for your rights and seek compensation when you have been wronged. Your host for Law You Should Know is attorney Kenneth J. Landau with the Mineola Law Firm of Shane, Dox, Denisi, and Corker. He's a member of the Committee on Professional Ethics of the Bar Association of Nassau County and counsel to the Nassau Academy of Law. And now, here is your host for Law You Should Know, attorney Kenneth J. Landau.
Hi, this is Ken Landau, and welcome to Law You Should Know. Our guest today is attorney James Alterbaum, and he's a partner with the law firm of Moses and Singer, and he's very involved with helping entrepreneurs to start a business or expand their business and also start up ventures. And he's been here many times before covering various business topics. Jim, welcome back to Law You Should Know.
Kenny, thank you so much, and it's a pleasure to be here and be here with you.
And a lot of people are thinking of starting a business, whether because of retirement or they think they have the next big thing. So what are some ideas, especially if they have an idea for a business or product, to protect their idea?
That's a great question. Probably the most important thing is don't get too enthusiastic about disseminating the idea to anybody you know, because, frankly, the idea and the conception of the idea is really the key to your success. So most people tend to want to talk about what they're doing with folks, and, they have to be careful about doing that. And there are a variety of tried and true methods to minimize the possibility of somebody usurping your concept, usurping your idea. And
what are some simple things they can try to do?
Well, the simplest thing is, frankly, and it sounds so simple, is that if, in fact, you're providing information to a third party and you can't secure what's called a non-disclosure agreement because you just can't, at least put on the document that you're providing confidential, not to be reproduced. At least it puts somebody on notice that this is not to be disseminated.
And if you have some kind of product, should you also want to protect that?
Oh, absolutely. If you have a product, you want to consider all types of protection. Many people think of patents, but the problem with patents, Kenny, is, as you know, is that it takes a long time to get them. And once they are disclosed, then the world does understand what's going on. So the tried and true method is still keeping things private and trade secrecy protection, which in essence means limiting the access to those with the need to know, and therefore keeping the idea, the products confidential until they really come to market. There are many instances where products are in their infancy stage. Don't disseminate them. Have suppliers sign NDAs. Have non-circumvention agreements. Probably the most important trade secret in the world is the Coca-Cola name and the modality of its formula, which has been kept secret for over 100 years, not by virtue of patents, but by virtue of keeping it in a need-to-know location with very little access to third parties.
And, of course, they have to think about the form of the business to protect themselves and protect their ideas. So what are your suggestions there?
Absolutely, and although it goes without saying, many people start out as sole proprietors, and they don't even think about the formalities of establishing a corporation or some kind of protection. But once you establish a corporation or a limited liability company, I would emphasize the following, that unless the formalities are kept, meaning that minutes are done, for example, in the case of a corporation, or agreements are done, there's always the danger of intermingling one's personal assets with the corporate assets. And courts have repeatedly in New York State attempted to, quote, pierce the corporate veil, because many entrepreneurs do tend to, because they're entrepreneurs, commingle their assets, have expenses on the business, things of that nature, and don't recognize that ultimately the protection of having an entity set up is to insulate your personal assets from your business assets. So I encourage everybody to form an entity. Now, as to the form of organization and form of entity, I happen to be a big proponent of Delaware corporations. Without getting overly technical, New York corporations do have certain disabilities, which I can mention if you'd like.
Just very briefly.
Very briefly, New York corporations protect minority shareholders so that if there's a 20% shareholder, that shareholder has the potentiality to dissolve a company. So having a partner with a 20% interest in New York is not exactly the best thing to do. Secondly, and there are many other things, but I'll point the second thing out, the 10 largest shareholders of a private corporation in New York have personal liability for unpaid wages and things of that nature. These disabilities are not present in other states, in particular in Delaware, where there's a tried and true case law that benefits an owner of a company.
And aside from which state, if you're signing a lease, you're ordering an agreement, you're ordering products, you do want to sign on behalf of the corporation and not personally.
Absolutely correct. And it's also very important, although it seems kind of obvious, that when a lot of folks sign stuff, they don't recognize they're really signing it personally. Every time you sign something and you set up an entity, just put your title down, put your name down, put it next to the company, because there's always an ambiguity, a possibility that signing it without reference to the entity could be viewed as a personal signature as opposed to a signature on behalf of an entity. The whole concept behind separating out your assets from the entity is just as I say. So absolutely a very important point.
And some people may be working out of their home, or at some point they may need some kind of industrial or office or retail space. What tips do you have for someone as they're looking for and they're arranging for space?
Well, when people are looking for space, they tend to overexpand and see that they need more than they actually do. There's nothing wrong with working out of your home. There's nothing wrong working virtually. In fact, in these days, as we all know, with technology being what it is, there are more and more virtual companies. So the concept of having space as such is less important. There's loads of folks who actually take space from dedicated offices for professionals. You don't need as much space as you need, as one would have thought. You don't have to sign a long-term lease. And by the way, if you do sign such a lease, try to have a separate entity that signs it, not your operating entity, so that you won't have exposure at your base business.
And as you said, there's like office sharing these days. So there's a common space that you can share with a number of other people. Very
common. And there are all kinds of organizations and incubators out here in the island, in the city, in Queens, which basically provide space for entrepreneurs at a very low-cost basis, with the added advantage of being able to share ideas with other entrepreneurs. And many of these incubators, and I'm involved with several, not only have the ability to participate and chat with folks of common thinking, but there are also speakers who come in who could help with marketing. So this is more than just a workspace, more than just a lease. It's a space where folks can actually interrelate with other entrepreneurs and coalesce ideas, and it's becoming more and more common.
And can you also have virtual employees? I mean, again, as a startup, and especially because of the economy has changed, can you at least initially avoid having employees or full-time employees?
Oh, absolutely. And in fact, outsourcing is very, very common these days, particularly in the financial officer area. I deal with a whole variety of companies that do outsourcing in all kinds of areas, whether it's HR, whether it's accounting, whether it's finance. So the whole concept of having employees and having the responsibility for withholding, workman's comp, all the kinds of things we both know are needed, is much less needed in the context of, as you put it correctly, a virtual office.
And in terms of initial financing, assuming someone's not ready to go on Shark Tank or not ready to have an IPO, what are some common sources to avoid or to consider for initial financing?
Well, that's a great question. The trouble with financing with third parties and with partners is the fact that you could end up with a partner who will not be receptive to your ideas. It's maybe a tough love kind of answer, but to the extent that one can finance with one's own resources and bootstrap financing through suppliers and bootstrapping it through credit, it's far better than to give up equity and then have an unfortunate partnership experience, which may end up in either litigation or bad blood. So to the extent that you can do so, that would be preferable. It is tough on a startup, a young company, to get a bank loan. It is tough to get an investor, but what is more typical is to find folks who are passionate about what you're doing, who are not only putting money in, but actually adding value in terms of strategic introductions. And many folks are getting concerned, how much do I give up for what? What's the valuation of my company? Well, you know what? What you really need to know is how much do you need to get this business going. Stop thinking about what percentage you have, because 100% of nothing is nothing. 25% or 50% of something is something. So don't over-negotiate. Try to do the best you can, but don't, in any circumstance, try to get crazy about valuation. Get that capital in.
And aside from valuation, is it more important for someone to have a business plan covering all these things?
Oh, absolutely. And business plans, though, again, sometimes are overdone. Folks who actually invest don't necessarily have the patience level to read 100-page business plans. So what we've seen much more these days are what's called teasers. And the teasers essentially will indicate security from indications of interest. There are securities law things to discuss way beyond the scope of this discussion. But having said that, having a teaser with your concept, with your idea, is at least a way to start the process. And if one doesn't put in all the terms and conditions financing-wise, I think it's better, because it avoids certain broker-dealer rules and securities law rules. But aside from legalities, Kenny, what it does is enable somebody else to tell you what your business is worth, and you don't have to start thinking about that.
And I also meant as a sort of as a startup, as a stepping stone for someone to put their ideas on these different issues that you've been mentioning into a business plan, just so they know what product or service they're offering and where they're going with it, the potential market, partners, etc.
Well, it's an excellent idea for a number of reasons. First of all, it actually provides a sort of way for an entrepreneur to put his or her ideas on paper, or, in order to analyze where the business is going. Exactly right. What is the competition? What are the ideas? What are the risks? So a business plan forms sort of an internal kind of document, which is a discipline for an entrepreneur. But it also can be used certainly for not only investors, but also suppliers, third parties, strategic partners. So it is something that's actually an important step in getting an entrepreneur going. But it doesn't have to be 100 pages. I have so many clients who say, it's not perfect. I say, it's not perfect. That's okay, but get it moving. Don't go crazy about every word and every page.
It's like a work in progress, and just someone might be writing their novel.
Exactly right. It's a work in process. It's almost like a living will. It changes, and it changes over time and can be adapted as times go on.
And you mentioned agreements that people may not get along, just like in a marriage. So if people are going to be partners with other people, should they have some type of sort of like a prenup? They should have like a partnership agreement or a shareholder agreement?
Absolutely. And, the interesting thing about that is that the best time to do it is right at the beginning, because the minute you start a business with a partner, the dynamics change. You'll find maybe one person works harder than another person has different views. So it's very important to get some kind of partnership agreement or a shareholders agreement, or in the case of a limited liability company, what's called an operating agreement. But what I do is actually I provide a template to folks who are looking to partner on the 20 or 30 action plan that they need to decide between the two of them or three of them. And those action plans basically dictate who does what and under what circumstances. And it's really a business document, and it formulates the basis for their business relationship, and then can be put into a legal document. So that's quite important.
And we're going to discuss other aspects of that in a moment, but we're going to take a short break, and you're listening to Do's and Don'ts for Starting a Business. Our guest is attorney James Alterbaum, and he's with the firm of Moses and Singer, located in New York. And as you've heard, he's involved with many business ventures and startups here on Long Island as well. You're listening to Law You Should Know here on 90.3 WHPC, the voice of Nassau Community College in Garden City, Long Island, New York, and also over the internet at ncc.edu/WHPC. We'll be back in a moment.
This portion of programming on WHPC is brought to you on behalf of the Nassau County Bar Association, helping both the public and lawyers since 1899. They are the largest suburban bar association in the country. The Nassau County Bar Association offers clinics where you can meet privately with an attorney to prevent or solve legal problems involving Hurricane Sandy, foreclosure, wills, or elder law. Speakers on almost any legal topic are also available to schools or community groups. They can also help lawyers advance their legal careers and offer a place to network. Learn more about the Nassau County Bar Association by calling 516-747-4070 or visit nassaubar.org.
Once again, we continue with Law You Should Know. From the Mineola Law Firm of Shane, Dox, Denise, Corker, and Sauer, here is attorney Kenneth J. Landau.
Hi, we're talking